Today, I'm going to tell you how to win your Missouri work comp claim, your work injury in Missouri. And workers' compensation in Missouri is a conspiracy. It's big government and large insurers combining with your employer to not pay you any money for pain and suffering. So you need to know these things to win the most money you can, because you're already getting less than you should, in my opinion, because there's no money for pain and suffering. If you're injured on the job, workers' compensation owes you three main benefits. The first is that they must pay for 100% of your authorized medical. So they get to pick the doctor, and we'll talk about that in a moment. Second, they owe you 2/3 of your average weekly wage while you're off. So you look at your rate, and we'll talk about this in detail in a moment, but you get 2/3 of your wages. After you miss 2 weeks, they owe you back the first 3 days. So you won't get anything for the first 3 days, and then you'll get that. And then the last thing, the last benefit, is for permanent and partial disability, or if you are unable to work for the rest of your life, permanent and total disability. And that's disability. It's not pain and suffering. It's for your inability to work. Permanent partial disability is paid in a lump sum, and permanent total disability is paid weekly over the course of your lifetime. And the employer is not required to pay you that in one large lump sum. So I'm going to break down how to win these workers' compensation cases today. I'm here with my associate, Jason Hackett. Jason is a brilliant, hardworking young lawyer. He's going to make sure I don't miss any issues. We have a whole workers' compensation team at Cantor Injury Law. And again, I've been doing this since 1990. So for 31 years, while I was in law school, I started at a boutique injury law firm, and I've been doing this since then. I've literally won thousands and thousands of these cases. I've given CLEs, which are continuing legal education classes, and to judges, even to Court of Appeal judges, to other lawyers that do what I do, and on the defense. And now I'm talking to you directly, the injured worker. If you have a case, you must file. It's different than a report of injury. A report of injury is you got hurt, you have a duty to report your injury to your supervisor within the first 30 days. So that's not a coworker or someone below you. That's saying to a supervisor, hey, I got hurt, and here's how I got hurt. And they'll ask you to fill out a report of injury. The statute of limitations, by the way, you got 30 days to tell them. If they do a report of injury, you have 2 years to file a claim for compensation, a formal claim. If they don't do a report of injury, the statute of limitations in Missouri for your work injury is 3 years. This is the claim for compensation. It's different than the report of injury. In it, you tell who you are, your social security number, where you work, how you were injured, and how much you earn. And Cantor Injury Law, me specifically, set the law on rate. That's how much you get while you're off, that 2/3 in a case called TH versus Sonic, where a woman was raped at work. And we put max rate, and the defense was she's not at max rate. You know, she earned an hourly rate. But they failed to file a timely answer, and that went to the Industrial Commission and to the Court of Appeals. That's still the law in the state of Missouri, TH versus Sonic. We obviously had some civil cases there too, but we're talking about workers' compensation today. Obviously, Cantor Injury Law handles the whole gamut of injury cases, but today we're talking about workers' comp. So how do you find out how much you get when you're off? And by the way, we don't take a fee on these non-contested benefits. You look at what I call the meat chart, and this is part of the workers' compensation conspiracy because, and we'll post a picture of this, if you get your thumb cut off at the mid-joint, you get 60 weeks of pay, and that separates us from the apes. I mean, so that's ridiculous, right? There's no money for pain and suffering or the fact that you no longer have an opposable thumb. And I've seen cases, by the way, where they've actually taken people's toes and put it on their thumb, and then you get disability at the level of the big toe, in my opinion, the foot, and at the hand. So your first thing is you look at this meat chart, and you determine how much you earn. And it doesn't matter if you're a, if you own a company or a neurosurgeon and you make a fortune every week, or if you're a lower paid worker or industrial worker. Once you get to 2/3 of the average weekly wage, that's all you get. Currently, the rate actually up to June 30th, 2020, the most you could get was $981.65 per week. And the most for permanent partial disability is $514.20. So you gotta look at the meat chart to determine how much you're entitled to get. The second benefit is your medical, and this is why it's a conspiracy. And I'll let Jason talk some here, but in Missouri, the employer gets to choose the doctor. That means that they get to pick the doctor, they hire him, and they pay for him. The doctors know that, and the doctors are smart. Some of them are great, some of them are not great. And I've had cases where I've taken doctors out of the game. I had a case that went all the way up to the Court of Appeals where the doctor testified my client had diabetes when in fact he did not have diabetes. And he said my guy's neck fusion wasn't fusing because he wasn't being compliant with his diabetic medication. Of course, that was a big fat lie. The Court of Appeals called him biased, uninformed, and not credible. So the doctors are part of the system. You got to be careful. They get an opinion, and we get an opinion. They get a rating. They do the surgery, and you see this all the time, right? Give an example of a rating for like carpal tunnel.
If you go in for carpal tunnel syndrome, bilateral, both wrists, we'll come back and the doctor will give a PPD, permanent partial disability rating of something crazy low, like 3% of the wrist. Now, you as the client have been through a pretty severe surgery. Your hands affect your daily life. If you can't use your hands, your life is altered dramatically. So even after a successful surgery, you're still going to have some PPD there. Obviously, we hope that you would have no disability because we want you to have full function of your hands because, again, they'll affect your daily life. However, that's likely not going to be the case. Although these doctors do great work, there are going to be some situations where you have disability after that. That's where we come in. You're going to get this low rating from a doctor, and again, like Marcus said time and time again, this is where this is a conspiracy. We as human beings are preconditioned to think that these doctors aren't going to lie to us. They have our best interest, and a lot of them do. However, you need to realize these doctors are hired guns for the insurers. We say this time and time again, and it's true. It's unfortunately true. And again, this is a conspiracy. We step in, and we send you to one of our doctors, who will then give you what we would think is a more fair permanent partial disability rating. Using that rating and the medical documents that come with that rating, that's where the fight begins. That's where we step in and we get you an accurate disability rating. And we use that medical evidence, whether it's a mediation or just through negotiations, and we come to a spot that's probably more accurate than what that doctor assigned you. And again, it's unfortunate, and without attorneys, we have clients all the time who call in and say, well, we get them late, and they say, well, the doctor gave me this disability. And we say, hold up. You need to know that this doctor works for the insurer. So for something like carpal tunnel, even a severe surgery, something that affects your daily life, again, like your hands, they're going to lowball you. They're going to lowball you on your disability rating, and that's where we come in.
Right. And they're doing thousands of these. So if the doctor makes their money by doing the carpal tunnel surgery for the large insurer, the huge employer, if it's a car manufacturer, their whole business model might be doing carpal tunnel surgeries for that doctor. And there's been hand surgeons that have been found to be like parrots, mimicking the words of their master. That's come straight from a case. So you got to know who's on whose side. At Cantor Injury Law, we only represent you. We never represent the employer, and we never represent the insurer. Never, not once. I've never charged a client by the hour because I believe in this system. If your case is good, I'm going to take it to trial, and we're going to win it. Now, unfortunately, there's a lot of lawyers now advertising in our marketplace that have literally never tried a case in Missouri. Look it up. I mean, people are advertising that they're bigger, but they're not even here, or they have one lawyer here. So the conspiracy is the law, which makes it so you don't get money for pain and suffering. And there's a lot of other conspiracies in the law, like penalties. We just had a seatbelt case where a person was in a car, a truck driven by a coworker that rolled. And we actually have video of our guy. He's in the cab and he's rolling around, and it's a violent accident and he was hurt. And the defense on that case said, aha, he's got a safety violation. He wasn't wearing a seatbelt. We're going to give him a 50% penalty. And Jason actually handled this. It was great. And I said, Jason, Cantor injury law will never agree to a penalty because the defense has the burden of proving that. I mean, we're good at proving our evidence because I've been doing it for 31 years. But the defense has the burden of proving that. And we have a standing policy. We won't agree to a penalty. And we didn't. And they paid without a penalty because a 50% reduction is ridiculous. And our argument to that was he wasn't wearing a seatbelt, but it's not a real rule because they have video on these guys all the time. What about the last 3 years, the guys in the truck without a seatbelt on? Did they ever once say something to him before the collision? No, they wait until the collision and they say, we only owe you half the benefits. So that's an example of the law being in favor of the employer because if the employer does something wrong, it's only a 10% penalty. So it's totally unfair. The employer has to pay while you're off, but they can schedule your doctor's appointments while you're working for an hour or two and not pay you. It's unfair, but that's the law. They can send you up to 100 miles away and not pay you miles in Missouri. Unfair, but that's the law. So you got to go to a lawyer that knows these things. These are just a couple examples. Did I miss any that you can think of? No. All right. So the law is unfair. It's stacked against you. The amount of money that you get paid is unfair because it's only 2/3 of your wages. And then lastly, of course, the lump sum that you get is unfair because it doesn't pay you for any pain and suffering. If you get your arm cut off at your shoulder, they owe you 232 weeks of pay times 2/3 of your average weekly wage. Or your wrist is 175, your knee is 160. So imagine getting your leg, God forbid, cut off at your knee and them saying, well, we owe you 3 years of pay, roughly 160, but at 2/3, so it's really only 2 years. And that's what you're going to get for all that pain and all that suffering. That's it.
And I think we say that because time and time again we have to have that tough conversation with clients about, you were severely injured. You injured your knee. Your knee's never going to be the same again. But you're only entitled to this much pay. And it is a tough conversation to have because we know what the client's going through. We know the pain they're in every day. And to say you only get compensated for this much by sticking your neck out for your employer, going to work every day, working hard as an American, and then you get injured on the job and now you're shortchanged because you went to work every day, you showed up, you worked hard.
Right. They don't pay you. And here's another deal in the law, and I've taught continuing legal education classes on this, a concept called subrogation. Let's say that you're the passenger in that accident where the truck rolls over and you get injured. If it's your driver's fault, that's your exclusive remedy. You don't get to sue anyone else. But let's say, and this wasn't the case here, but let's say another truck hit that truck and now you got severe injuries and you want to claim workers' compensation, which you should, and you want to sue the truck that hit you. So let's say we get you $100,000 in workers' compensation and $2 million in the civil suit. Well, guess what? There's something called subrogation where you have to pay back the work comp carrier. And it's not just the $100,000 that they paid you for your permanent partial disability. It's also the medical and the time while you were off. So we're experts on subrogation. You've got to settle your workers' compensation case first if you have both a civil case and a work injury, because otherwise it acts as a complete credit. If you take the $2 million in the trucking accident first, then comp says we don't owe you any more money, and they're right. So that's unfair. That's what subrogation is. So we handle the whole gamut of injury cases. We had a client that got bitten by a dog while making a delivery. In Missouri, there's strict liability for dog bites. So that means your homeowner owes it no matter what. And you got to handle the work comp claim first. And by the way, if you get a scar, that dog bites you on the leg and you have a scar, a big scar on your leg, here's another fraud in the law, you don't get any money for disfigurement because disfigurement only works from your neck up or your arms down. So if you have a large scar in the mid part of your body and you're a lady and you're a bikini model on the side, you get $0 for that under workers' compensation, even though you have a disfiguring scar there forever. Because a scar has nothing to do with disability. It's just the way you look, and the law doesn't care about how you look. It only cares about how you work. So, originally workers' compensation made it sound like they were giving you something. Here, injured worker, we're going to give you these benefits. They're trying to sell it to the masses, and they did. It's not workers' compensation. It's a fraud. They're not giving you any gifts. They're taking away your ability to sue the employer. So you don't get any money for pain and suffering. It's really, honestly, completely unfair. So when we have a claim and a client comes in and we take them all the way through the case and we try these cases, if they're cheating you, we'll go to trial. We try these cases all the time. We mediate these cases all the time, even during COVID. That's what we do. Because if you let them know that you're not going to try the case, they're going to cheat you every time. And by the way, they keep track. So ask your lawyer if it's not us. And by the way, we don't want a case that's 2 or 3 years out. We already have a lawyer and they're not doing, stay the course, okay? Call that lawyer, don't call us. We don't like to get involved late. If you have a serious injury case, call us first. If you have a civil case and a work comp claim, we'll help you, but we need them both. We sometimes get people that, called a law firm and they said, I got injured on the job, and it was a civil case too, like that trucking accident. And they say, oh, well, we'll handle the civil case. No, you got to handle them both. They don't even want to touch the work comp. They probably don't know where the courtroom is because they're from Florida. So, if you have a work injury and a serious injury case, do your research about who knows what they're doing, and then call Cantor Injury Law. We're available at 314-628-9999 or cantorinjurylaw.com. I'm sure I've missed some issues here. Is there anything else that we should
Nothing
add?
that comes to mind. I mean, like you said, just let us know early if you're injured. We want to know as soon as possible. There is that 45-day waiting period. After we file the claim, the division acknowledges it, and the insurer has 30 days to supply an answer. The sooner you get to us, the better.
Right, it's 45 days, right? You file right away, and the division acknowledges it within 15 days. And then the employer, it's like playing tennis. So you come to us, we serve. That's the claim. The court tells the other side that the ball's been served. They do that within 15 days, and then the defense has 30 days to return the serve. If they don't return the serve, then we're going to go and take a default, and we're going to just keep pushing them. You got to get to us early, because if you wait until you're done with medical care, you say, oh, they're going to provide me my carpal tunnel surgery, and then what happens is you also have a problem with your elbow, and let's say it's a fall, and they ignore it. Well, now they return you to work, and you're like, they fixed my wrist, but my elbow's still hurt, and you come to us. Well, guess what? We're 45 days out before we can even be in front of a judge. So we don't take a fee unless we win. We charge 25% of that lump sum only, unless the other things are disputed. Like, we have a lot of people that are off work and they stop paying them. And if we go to trial and we win you those back wages, you will agree that we've earned our fee. We do a lot of work. We fight for if we win you a benefit, we've earned our fee. If we don't have to fight to get you a benefit, we don't charge a fee, because that's what's fair and that's what we're trying to do. I'm blessed that we've got a great law firm, that we've got a lot of business, that we have, when someone gets hurt, really hurt in Missouri, and they ask a judge or an adjuster or a doctor who to go to, they send them to us. Quietly sometimes. It's a big honor when we represent insurance adjusters that get injured on the job, or when conservative doctors say, you really beat me up in that deposition, and this person who I'm friends with got hurt, so we sent them to you. I still don't like the doctor, but I appreciate that they sent us the case. So if you have a serious, real injury case anywhere in Missouri, please call us. We have offices throughout the state. We're now doing some of these things electronically. So some of the mediations are done because of COVID virtually. I can't wait till we're all back in person and the masks are gone forever. I guess that's starting. We're getting over the hump. So thanks, and thanks for watching.